Good afternoon, ladies and gentlemen, and welcome back to Meeting the Threat, a symposium on counterterrorism, which is sponsored by Duke's program in public law. For those of you who are just joining us, my name is Tyler Friedman. I'm a second-year law student here at Duke, and it has been my great privilege to organize this symposium. It is both an honor and a privilege to be able to introduce our keynote speaker this afternoon, Michael J. Garcia, the Assistant Secretary for Immigration and Customs Enforcement, better known as ICE. The theme of this symposium is counterterrorism, and it would be hard to find a government official who has had more counterterrorism experience than Assistant Secretary Garcia. Prior to his appointment at the Department of Homeland Security, Mr. Garcia was a federal prosecutor in the United States Attorney's Office for the Southern District of New York. I had the privilege of working in the Southern District before I came to Duke Law, and it is fair to say that Mr. Garcia's reputation as an exceedingly talented prosecutor lives on in the office. The Southern District rose to terrorism prominence in 1993 after the first attack on the World Trade Center. Even more impressive than the expertise that was built up in the Southern District in the 1990s was its 100% conviction rate for all terrorism-related cases. Mr. Garcia played a prominent role in nearly every Southern District terrorism prosecution. Most notably, Mr. Garcia successfully prosecuted the 1993 World Trade Center bombing, the 1995 quote-unquote terror in the sky conspiracy, in which Ramzi Youssef was convicted of conspiring to blow up 12 American airliners in Southeast Asia, and the 1998 U.S. Embassy bombings in East Africa, which were plotted by al-Qaeda leader Osama bin Laden. In 2003, President Bush appointed Mr. Garcia to head up U.S. Immigration and Customs Enforcement, which is comprised of 5 integrated divisions that form a 21st century law enforcement agency with broad responsibilities for a number of key homeland security priorities. In his role as the leader of ICE, Mr. Garcia heads the second largest investigative agency in the federal government. Among its many responsibilities, ICE has the challenging task of enforcing the nation's immigration and customs laws and securing the airways with the Federal Air Marshal Service. The success of ICE and its prevention of terrorist attacks in this country is a tribute to the leadership, ingenuity, and diligence of Mr. Garcia. Despite the enormity of his responsibilities to our country and the limitless nature of his challenges, he honors us with his presence here today as the centerpiece of our counterterrorism program. On behalf of Duke Law School, it is my great honor to present to you all Assistant Secretary Michael Garcia.
Thank you very much. Thank you, Tyler, and thank you for the invitation to be here today and for all your hospitality since I arrived on the Duke campus. I also thank Dean Kate Bartlett and Chris Schroeder, the director of the program in public law. It's really a great honor to be with you here today at Duke's Symposium on Counterterrorism. I know many of your guests and panelists and know that each one of them could teach a course on counterterrorism. Many of them have or will or still are on the front lines of investigating and prosecuting terrorists or protecting our homeland and national security. Although, as Tyler said, I'm now an Assistant Secretary for Immigration and Customs Enforcement at Homeland Security. My own involvement in the effort against terrorism started with the case involving the 1993 bombing of the World Trade Center by Ramzi Youssef and his associates. It was at that time in 1993 considered the single most devastating act of terrorism ever committed on U.S. soil. 6 people were killed. Since then, we have had a terrible education in international terrorism. I would like to start talking about that education in those cases, not at September 11th, 2001, now a globally recognized milestone in our war on terror, but instead, I will begin at a much earlier milestone, September 1st, 1992. And I believe that was the day that international terrorism arrived on our shores. On that date, Ramzi Youssef and Ahmed Ejaj arrived at JFK Airport in New York from Pakistan. They had traveled together from Peshawar to Karachi in Pakistan and split up for the flight to New York, checking in separately and getting separate seats in first class for the flight to the U.S. Then, as later, terrorists believed they would get less scrutiny in the front of the aircraft. In New York, when the plane landed, there was a carefully orchestrated scene. Youssef, dressed flamboyantly in a silk suit of striking colors, walked off the plane, held up an Iraqi passport, and claimed political asylum. Ejaj proceeded to primary inspection. He was dressed in a suit and tie, had a Newsweek under his arm. He claimed he was a visiting journalist, Sweden was a visa waiver country, so he didn't need any other documentation to get into the U.S. His Swedish passport was a stolen document that had been photo substituted. Inspectors discovered that Ajaj's picture had been pasted over the original and sent him to secondary inspection. In secondary inspection, his luggage was examined. He had printed and handwritten materials on terrorism, everything from how to make pipe bombs to rockets. It was, as he would later call it, a virtual encyclopedia. He also had videotapes showing the mixing of chemicals. One had a dramatization of the bombing of a U.S. embassy as a lead-in to a bomb-making tutorial. He had all the necessary forms and materials for terrorist travel, 5 or so other passports, numerous fraudulent documents, and backup materials such as school and other records that could be used to create new identities. It was perhaps the most extensive collection of terrorist materials ever seized by U.S. law enforcement. Ajaj also had his legitimate Jordanian passport, which he quickly produced, and with which he too claimed political asylum, or more accurately, restated a claim he had made in the United States before mysteriously disappearing into Afghanistan in April of 1992. Both Ajaj and Yusuf claimed to be traveling alone. Ajaj was detained and charged with passport fraud. His belongings were seized and turned over to investigators. Yusuf sparked interest as well. He struck inspectors as dangerous and they recommended detaining him. They were overruled. Yusuf was fingerprinted, photographed, given an appearance date for an immigration proceeding, and sent off into the night. 6 months later, he and 5 or 6 co-conspirators would drive a van loaded with urea nitrate into the underground parking garage at the World Trade Center complex. At first, the bombing was thought to be a transformer explosion, although once it was established that it was a bombing, remarkable progress was made in the investigation, particularly remarkable in that law enforcement was so utterly prepared for the event. We hear a great deal these days about the Joint Terrorist Task Force squads, and there may be members here today. At that time in New York, the FBI's field office had about 2 squads. There are now 20 in New York alone. None of those agents had done any international terrorist investigations, and most had never done any criminal investigations at all. They were from the intelligence side of the house. Some mistakes were made. For example, agents in New York returned at least half of the Ajaj terrorist kit to his immigration lawyer a few months after his arrest on passport fraud, including some letters that were still sealed and sent and addressed to unknown recipients. And as for being a multi-agency task force, there was half-hearted participation by a very few other state and federal law enforcement agencies, but most of the non-FBI personnel who worked the investigation would join the JTTF immediately after the bombing. The U.S. Attorney's Office for the Southern District of New York also lacked any experience in this arena. Of course, we had no terrorism or national security unit. We had no prosecutors with experience investigating or prosecuting international terrorism. Instead, the lead was given to experienced organized crime attorneys who had prosecuted major mob cases or violent drug conspiracies, and to 2 very junior general crimes assistants with a great deal of experience in writing complaints for cases that no senior unit in the office wanted. And one of those was me. So we had intelligence officers with intelligence agents with very little experience in criminal cases. We had prosecutors with no terrorism litigation. And we were working off a statute book with criminal laws that did not fit this new type of crime. There were no terrorism statutes. There was no use of weapons of mass destruction. There was no acts of terrorism transcending national borders. Those violations would be added to the code later, after the verdicts in the '93 bombing. We used what was there at the time, and that included primarily damaging and destroying a building used in interstate or foreign commerce. And we figured we had a pretty good shot at that with the World Trade Center. And then we used the statute prohibiting damaging or destroying vehicles owned by the government because the Secret Service had parked cars in the basement of the garage that had been destroyed. And some of these charges, actually, because death had resulted, carried a death penalty. The penalty was death or any term of years. Unfortunately, the death penalty had been found unconstitutional as written years before. The statute had never been corrected, so the death penalty, in effect, was not available for those charges. What we had was any term of years. And that phrase alone would cause a lot of litigation after these defendants got sentenced to 240 years in prison. But in our efforts to charge every crime available, we also added Travel Act violations and even immigration fraud charges. It's not very well remembered today that Mohammed Salameh, one of the principal co-conspirators, was actually also convicted in that trial of special agricultural worker fraud. They said we used everything. But the investigation was remarkably successful despite the lack of experience in terrorism or of our agents and prosecutors and the absence of statutes that were tailored to terrorism. The case broke with the identification of a vehicle identification number. It was found in the hole inside the Trade Center. It was really remarkable because I remember seeing that crater. And they pulled a piece of the van up, and it had a VIN number, which really not many people knew what it was at the time, but it enabled us to identify the van. The FBI went to the rental shop where that van had been rented shortly before the bombing, and in so doing, they were able to make the first arrest, and other arrests followed. From there, we used typical association evidence as phone records, bank records, travel records, and we linked the co-conspirators together and to the bombing. It was a 6-month trial, and all 4 defendants were found guilty on all charges. It was the beginning, and it led to a number of changes. Changes for investigators. The Joint Terrorist Task Force became more robust as a multi-agency task force, and a close relationship, and this was very important, a close relationship developed between the agents on those squads and the prosecutors who worked at the U.S. Attorney's Office. Really, before this bombing trial, it had been investigations and then here prosecutions. That model very much changed after the Trade Center. There were changes for the prosecutors as well in our office. A new unit was formed at the Southern District called Terrorism and Organized Crime, and there was a long-term commitment made not only to continuing the World Trade Center investigation to find other co-conspirators, but to look into potential terrorist activity, and the program became very much more proactive. And as I said earlier, the laws changed. Statutes were enacted, the death penalty statute was amended, and those new charges on use of weapons of mass destruction and terrorism were put into 18 United States Code. And with the indictment and meticulous chronicle of the co-conspirators' conduct that happened over that 6-month trial, often in excruciating detail that the press got very frustrated with, there came from that a realization of the need to use all our statutes, all our powers, all our authorities in the effort against terrorism, like those immigration charges I mentioned. This was particularly a telling point because almost all of those World Trade Center bombers had violated our immigration law. We had passport fraud that I talked about earlier. We had special agricultural worker fraud, other benefit fraud, asylum fraud, and we had the driver of the van come in on a student visa but never attend school. We learned the importance of forensics related to bombings, particularly explosives, chemistry, and we learned of problems with the crime labs that would later be explored by the Inspector General. It was a successful prosecution against 4 of the co-defendants, the co-conspirators in the World Trade Center bombing, and they each received 240-year sentences, and despite some litigation on that front, each will spend the rest of their life in prison. But Ramzi Youssef, the mastermind of the '93 Trade Center attack, had fled the U.S. on the night of the bombing. At the time of the verdict, in that first case, he remained a fugitive. It was thought he was hiding in Afghanistan and wouldn't be seen for some time, because he and Ajaj had in fact attended a terrorist training camp before coming to the United States and Afghanistan. But instead, Youssef surfaced fairly soon in Manila in the Philippines, where he once again had assembled a bomb factory. Fortunately, this time a small fire in that apartment got the attention of the local Philippine police, first responders, who came into the apartment and actually arrested an associate of Youssef, then arrested a second associate, who were eventually turned over to the U.S. Ramzi, following his usual MO, had fled the Philippines on the night of the fire, gone back to Pakistan. But his luck ran out about a month later when he was arrested in Islamabad, again with explosives all around him in the room, including some cotton he had treated to become an explosive that he had then placed in the heads of dolls and other items to be smuggled aboard planes. When we looked at the evidence in Manila, particularly some files off of his laptop computer, it revealed that Youssef was about to launch a new wave of attacks against the United States. He was going to plant 12 bombs aboard U.S. jetliners, timed to explode while those planes were airborne and full of passengers on their way to the U.S. There would have been 2 waves of near simultaneous explosions. Youssef, at the time of his arrest, claimed to be weeks away from launching this attack. In fact, he had taken a test run planting a bomb aboard a plane that was going to Japan, and he had killed 1 person and almost taken down a 747. The trial of Youssef and his 2 co-conspirators in New York and the airline bombing case really also broke new ground in terrorist investigations and prosecutions. There was no crime scene in the U.S. All evidence, all fact witnesses had to be brought to U.S. District Court from overseas. The FBI legal attachés, who were agents stationed overseas, played a crucial role in this investigation. From serving a basic routing function in the past, where they would receive leads from the U.S. and basically just pass those on to their foreign counterparts, they became very active participants in this investigation, side by side with those foreign counterparts. The program expanded. On my first visit, I went to Jordan. We were trying to extradite one of the Trade Center bombers. They sent the legat with me who covered Amman, Jordan. That legat was stationed in Rome. The FBI didn't have any legats, any agents stationed in the Middle East. Now they're in many of the Middle East countries and in dozens of other countries worldwide. We used those new statutes I talked about. We used use of weapons of mass destruction. We used acts of terrorism transcending national boundaries. It was one of, if not the first prosecution in many of these areas. We used a novel certification process to certify, it was in the statute book, hadn't been used much, to certify records, ordinary course of business records, from overseas without having to call a witness. And the importance of those records in the trial couldn't be underestimated because of the way the Philippine authorities kept phone records with names of who was calling and who was called, the way they kept logbooks from buildings, security logs showing who was entering, who was exiting, and the time. And we successfully litigated novel issues of extraterritorial jurisdiction. At the end of the day, all the defendants were convicted of all counts, and it was a validation of an effort to prove a case involving acts of terrorism aimed at the U.S. from abroad, where all overt acts in the conspiracy took place overseas, and it was a crime in which no Americans were killed. One of the defendants in the Manila airline bombing case was Wali Khan Amin Shah. He had been a commander in the Afghan war against the Soviets, and he was a close associate of Osama bin Laden. Another indicted co-conspirator in the airline bombing case, indicted in 1995, was Khalid Sheikh Mohammed. He, of course, would go on to plot the 9/11 attacks. The 95 airline bombing case was, as far as I know, U.S. law enforcement's first real brush with al-Qaeda and Osama bin Laden. Over the next few years, bin Laden would go public with his threats against the United States, and in June 1998, he was charged in a sealed indictment in New York with plotting to kill Americans. 2 months later, bin Laden's East Africa cell orchestrated the simultaneous bombings of the U.S. embassies in Tanzania and Kenya. More than 200 people were killed, mostly Kenyans and Tanzanians. Many of the dead were teenagers studying at a secretarial school across from the Nairobi embassy compound in a building that was leveled in the blast. 4 defendants stood trial in New York for these attacks. Bin Laden was charged with the embassy attacks as well as the original charges. There was a death penalty for the case for 2 of the 4 defendants, and this was the first death penalty proceeding in New York in more than 30 years. Again, all the evidence was brought back to U.S. courtroom from overseas. There are many issues involving the use of classified information and litigation under CIPA to that effect. There were novel issues of statements made overseas, and I think Andy McCarthy might have mentioned one of those this morning. And we worked very closely with the intelligence community in this case, showing them that their information could be used in court or it could be protected from disclosure. And it was a very productive partnership. It was actually a very long way from the first Trade Center case where, after the verdict, we met a team of CIA analysts who had been studying the bombing for the first time. And in fact, at that meeting, they asked us what we could do to prevent international terrorism, and we had never met them before. We forged a real partnership with the intelligence community. Once again, all defendants in the embassy bombing case were convicted, 300 counts, but the jury in the death penalty phase was unable to reach a verdict, and under federal law, a life sentence without parole was imposed. One of the mitigating factors that at least some of the jurors gave weight to was the idea that by not imposing the death penalty in this case, we would send a message to bin Laden and other terrorists that could prevent future attacks. The date was mid-July 2001. On September 11th, 8 weeks later, bin Laden gave his response. One of the FBI agents I had called as a witness in the death penalty phase of that trial was on his way to the office when he saw the towers in flames. He ran in to help and was killed in the collapse. He was one of 3,000 victims. So was a man who had survived the first bombing, who had told me he was nervous about going back into the towers because he thought there might be another attack. Are criminal investigations and prosecutions enough? Clearly that day showed they are not. Not now, not then. Eliminating the Afghan sanctuary, a sanctuary that was the launching pad for each of the terrorist attacks I just spoke about, was indispensable to the war on terror. Intelligence gathering and dissemination is critical as well. But these necessary and valuable initiatives or efforts cannot be considered exclusive. In preventing attacks, we do not always forego later prosecution of co-conspirators. By labeling information as intelligence, we do not necessarily bar it from ever being used in court. We still must approach terrorist cells and plots, the risks of terror in the United States, with traditional law enforcement tools, albeit in new ways. So I take the final few minutes this afternoon and speak to you a little bit about what I am doing now at the Department of Homeland Security and Immigration and Customs Enforcement, in a department that was formed to address some of the vulnerabilities exposed by the September 11th attacks. What we do at ICE is use many of the tools that we realized were so valuable in the counterterrorism fight, immigration and customs law, and we have many tools. There's been much talk about terrorist financing, and it's incredibly important work. Take a little bit of a perspective on that. According to the 9/11 Commission report, we still do not know where the money came from that financed the 9/11 attack, and it was about $500,000. The World Trade Center attack, that plot probably cost in the neighborhood of $20,000. At Homeland Security, rather than looking for the specific financing trail, we use a different approach. We use the old customs financial shop to look at, for example, unlicensed money brokers under the Patriot Act, ways that terrorists could earn, move, and store funding. In one case in New Jersey, we had unlicensed brokers sending millions of dollars in cash to Pakistan. Very difficult to make financing cases because it's very difficult to trace the money overseas. It's very difficult to put the money in the hands of the terrorists. So we brought charges based on these Patriot Act counts, unlicensed money brokers. We brought felony charges. We seized money. We seized assets. And we put that business, out of business, that operation. And we stopped that flow of money into a country and an area of that country where it was causing great concern. We have export control laws aimed at keeping weapons and sensitive technology out of the hands of terrorists and state sponsors of terror, violations I knew nothing about when I was working the embassy case and the cases before that. We address vulnerabilities in our border security, particularly by alien smugglers. We go after those organizations, and now, unlike the former INS, we have a financial crime shop, and we go after the assets of alien smugglers. In Phoenix alone, in one operation in the past year, we seized about $7 million from alien smuggling organizations. And ICE has created a compliance enforcement program aimed at ensuring that visitors, students, or tourists comply with the terms of their entry documents into the United States. The 9/11 Commission also found that had we, prior to that attack, ensured some consequences for routine violations of these laws, law enforcement would have come in contact with a number of the hijackers and might well have disrupted the entire plot. We now work to ensure those consequences. We look to investigate benefit fraud, SAW fraud, asylum, and other benefit programs. We use our more than 56 foreign attaché offices around the world to help investigate what, by definition, are cross-border crimes. Last year, we used our authorities to lead more than 300 JTTF cases in the now more than 100 JTTF locations across the country. At ICE, we are trying to take this comprehensive approach to the fight against international terrorism, an approach that builds on some of those lessons learned in the 90s and in the aftermath of 9/11. The landscape has been irrevocably changed in our fight against international terrorism, but there are landmarks still there. Milestones, investigations, and prosecutions dating back to that September night in 1992. There are lessons, there are successes, there are failures. For some, we have paid a terrible price. I am confident that we have learned and have improved our capabilities. I see things every day at airports, at seaports, and at the border, in law enforcement generally, that show vast improvement in our security. Balances are being struck in favor of national security in a way far different than the approach used to make the decision to release Ramzi Youssef into the United States. I hope that this brief overview, a part of the history of investigating and prosecuting terrorists, and there's more of that history in this room, has provided some insights into the process. As those cases progressed from the garage beneath the Trade Center to an apartment in Manila, to our embassies in East Africa, and then back again to Ground Zero in Lower Manhattan. Once again, I am very honored to be here today and to continue to be part of America's response to international terrorism as part of the new Department of Homeland Security. Thank you. I think Tyler can take some questions. Yeah?
Garcia will.
Sure.
Could you comment on the fact that he came in with an Iraqi passport?
Yeah. I actually thought about talking about that a little bit in the speech, but he came in with an Iraqi passport. It was actually a legitimate Iraqi passport. It was a stolen blank, and we see a lot of problems with these. Dave Stone, who runs TSAs here on your panel as well, knows very well about them. He obtained one of the batches, legitimate Iraqi passports had been stolen from a consulate somewhere. Yusuf obtained one and created from that blank the Ramzi Yusuf identity, which he then continued to use for many years. His actually real name was Abdul Basit. He was a Pakistani national from the Baluchistan area. But it highlights an issue with stolen passports that we've really tried to hit very hard. There's new databases, there are Interpol databases that list those passports that show up in an inspector's screen when they hopefully swipe them now with the new technology. But it's a serious problem and nowhere highlighted better than in Yusuf's use of that Iraqi passport.
Assistant Secretary Garcia, there's one of the great difficulties that ICE has to deal with is the presence of maybe 8 to 10 million people who are not properly documented in the United States, among whom potential terrorists can hide. Recognizing what I think is a near impossibility to deport all those people, I'm going to ask you to step outside your role as an executive a little bit. Are there legislative proposals that you would like to see enacted that address the difficulties and that provide some umbrella for better security?
Yes. There's a lot of talk right now about a temporary worker program. I don't believe there's any legislation on the table right now. It's more along the lines of ideas. The President proposed it more than a year ago. I think we need that. I think we need it because, as you say, we have 8 to 10 million. There are various estimates. Better to put in place some type of system, define a benefit, and move forward than to continue to say we're chasing 8 to 10 million people around the United States. But I think that enforcement has to also drive that program. I don't think it's a good idea to create a program and then take care of an issue now and then see that issue again 10 years from now. I think we define the benefit, we define counter-fraud methods and procedures that build on some very painful lessons that we learned in the past, see special agricultural worker fraud, and go forward that way. And I think, honestly, that the way that will go, I think should go forward is with that expertise, kind of lessons learned, working with the benefits people to get us where we need to go. I don't think anybody wants to kind of cut the pipeline now, do something, and then just have the area filled back up again with the same problem. So I do think we need it very much, but I do think also enforcement has to be a part of it.
I want to ask, given our law school setting here, about the programs that ICE is running for foreign students and exchange programs. I know we had one of your colleagues here just a couple weeks ago that spoke to some extent about programs that ICE is doing, and I'm wondering, just at a macro level, if you can talk about how we can take the necessary security measures while at the same time not overly discouraging a group of people that we very much want to come and introduce to American culture and norms and concepts as building long-term security in our international relations.
And I think you phrased the question very well. That's exactly what we have to do. The program we have in place right now is CVIS. It's a web-based program. The problems we had in the beginning were technology-based. It was a completely new system. The system actually works, and it works very well. It goes to the inspectors at the port. When students come in, it's a painless login procedure. The school has certain obligations to report if somebody doesn't show up and attend, like Iyad Ismail, who never went to Kansas and drove the van into the World Trade Center. On the other hand, we now are seeing more issues with the issuance of visas overseas, which is State Department, and I don't mean to push it on the State Department, and working with the State Department is working very hard to address them because they're approaching it exactly the way you say. You hear a lot of numbers, students are down, and I think there are recent stories about international students, a lot of reasons for that, I think, economic, et cetera. But the CVIS system itself, and I have both the program and the enforcement side of it, works. I think it's a good system. I think it's fair. It doesn't place unnecessary demands on anyone, but it gets us the information we need. Now, of course, within that, universe of leads that we get out of CVIS, we try to do the best job we can to scrub them to make sure someone hasn't gone to another school, or we don't want to be doing that, or left the country, which happens in many cases. So we'll do a certain percentage and try to get in a deterrent effect, to have people comply with the requirements of their entry, and as you do with all law enforcement programs. But it is a balancing act. And I think we've struck a very good balance with the CVIS program, and now I think work continues to be done on trying to do some things with the visa system overseas, which is a different piece.
You sort of told two overlapping stories, I thought, about this sort of our efforts to deal with this early wave of terrorism. One was sort of a story about insufficient laws, and the other was a story about insufficient expertise or resources. And as you look back on it, I wanted to ask you, did the laws that we had on the books, you identified a number of examples where we've had new laws that now make this task easier. The question I wanted to ask you is, as you look back, did the laws we had on the books at that time, were they sufficient to do the job? Because when you told the story about the individual who came in with this encyclopedia of terrorism materials, only to be released when the supervisor overruled the decision to keep him, I was wondering, was it really a matter of insufficient law, or was it really a matter of we just didn't know what we were yet dealing with?
Well, I think it was both. If you look at the laws, you always, I think, approach it as, do you have a statute that resembles the conduct? Not only because it makes it easier for you to prove. In the end, we proved those charges, bombing buildings and interstate commerce and cars in the cellar, and we did those things, and what other penalty was available there? It was a life sentence, and they got life sentences in essence. Two things. I think you want your proof and your case to be tailored to a violation. In these cases, the use of case in the Manila, very good example, World Trade Center 2, we had notes saying we're doing this because we want to influence the foreign policy of the United States, we want to change our policy with respect to Israel. It was very pure terrorism aimed at a political, changing a policy of the United States, which those later laws get into. And, well, yeah, it does make it easier to put your proof in because it's easier to convince the judge it's relevant, but it also makes a better statement. We're not prosecuting you for tax fraud, we're prosecuting you for terrorism. And that, I think, is worth it. It also changed penalties. It imposed life sentences rather than this term of years, which was a very good thing to clarify the law there. And it gave an option of a death penalty. That was constitutional. So I think we needed the laws, but clearly some of the issues we had originally were not because we didn't have a statute on the books we could prosecute. We had to be a little creative. It was because we really had never seen anything like this here.
I want to ask about exit tracking. A lot of the coverage of ICE has to do with entry tracking and then also the question of matching up entry and exit. Your story about Ramzi Youssef is very interesting. I hadn't realized that he claimed asylum when he came in.
Yeah.
And I would wonder if maybe something would have been flagged if we'd had a system that recognized not just someone who comes in and has a visa that we expect to leave, but someone who comes in and claims asylum perhaps is someone we don't really expect to have leaving 2 months after he gets here. I'm wondering if there's a more comprehensive exit tracking that's intended or needed in order to look for situations like that, not simply the exit-entry matching.
It's a great point. It's called U.S. Visit, the exit system. When you look at U.S. Visit, which is supposed to track entry-exit, basically at some point become a click-in, click-out system. Think about how we had to go to get that. Well, we're still not there, but we had nothing. We had an entry system. It was okay. The northern border was pretty wide open. And now we have a very good entry system. Still northern border issues, but U.S. Visit is one of the successes of the department, I really believe. But, you're thinking of land ports. Think of the southern border. How do you do exit controls on the southern border, land border? If you've ever been to Tijuana, the crossing there. It's very difficult. But your other point, most of the traffic you would probably get that would interest you in that front would be airport traffic, where the exit entry controls are very good. You're right. We knew how to do that then. Even when we found it, though, Ajaj, who the other guy we were traveling with, Yusuf, had claimed asylum here. And then he left. And he went to Afghanistan, to this camp. And then he came back in. And then he pulled his passport out when he kind of got caught. and was, now I want to renew my asylum claim, and they basically let him do that. In fact, when he was released, when he served his passport fraud term, they let him go. Even though he had all this stuff, he hadn't been tied to the bombing yet, or it was after the bombing, they released him. And he was living in Brooklyn, about to pick up the pieces and resume his asylum application, thinking, nobody had connected him to the bombing. So I think it is a very important thing to look at. There's a large amount of fraud in that program, and you, again, have to prioritize your cases as well. A lot of it involves investing resources to go overseas and track down a story, that's most likely false. But then you have to bring that back to an immigration court, convince a judge. So it's resource intensive, but I think it is very important.
With the amount of money that's being spent on checking containers that come through the southern border?
I don't run the inspections function. It's a Customs Border Protection function. There was a lot of talk. I'll dive into it briefly. There was a lot of talk during the election, I think, particularly about we only X-ray or we only examine a certain percentage, I don't even know what it was, that they were using of container cargo into the United States. That is really a red herring of an argument. You got to look at a couple of things. What is the volume of traffic, which is unbelievable, of containers? A lot of it is from repetitive, trusted shippers that have had their procedures for securing those containers validated and approved by the government. So, yes, but you want us to target the containers that rate, and then do some random searches. To X-ray a container, even with the new technology, takes a long time in terms of a border crossing. You would shut the borders down if you looked in every container. It would be, and we have an obligation at Homeland Security to balance the free flow of goods and people, legitimate flow of trade and people, with security measures. You're never going to be able to strike that balance if you're looking in every container. So you have to do other things. And there's also a container security initiative that stations U.S. inspectors overseas to look at ports and how containers are loaded, et cetera, over there to help us do that targeting better. So I think all of those things, that's the right approach. You could argue about what's the percentage should be, but you're going to at some point have to make a judgment there. Thank you very much.
Thank you, Mr. Garcia, for the engaging presentation. We will begin our second afternoon panel momentarily. We just need a few minutes to transition a little bit, and we'll get started shortly.